This is Lyons McCluskey's Foreclosure Basics course, a beginner's guide to the foreclosure process, part 1 of a 2-part course. My name is Douglas Bales. I'm in-house counsel at Lyons McCluskey, and I'll be presenting this course for you today. This is a high-level course designed to give you a basic introduction to the foreclosure process. In this course, we will cover some basic definitions, the prerequisites to foreclosure. We will also cover in detail the judicial foreclosure process, and we'll include comments on certain risk junctures for borrowers facing a judicial foreclosure. We will also briefly touch on the non-judicial process and loss mitigation during foreclosure. In addition, we'll discuss the effect of bankruptcy and foreclosure fees. And at the end, we will provide you with a wrap-up and summary and some general takeaways. Before we get started, I should tell you a little bit about myself. My name is Douglas Bales. I am in-house counsel for Lyons McCluskey. I'm a board-certified real estate attorney with 35 years experience in real estate and foreclosure law from the state of Florida. I'm the former managing partner and co-founder of a successful law firm that specialized in foreclosures, title, and REO closings. So let's start the course with some basic definitions. So what is a mortgage? A mortgage is a written contract between the borrower and the lender that creates a lien on real property to secure the repayment of a promissory note. The mortgage form is typically utilized in judicial foreclosure states, and a deed of trust form is typically utilized in non-judicial states. There are two general lien theories in regards to mortgages. First, there is the lien theory, which is utilized in several states such as Florida, Ohio, and New York. In a lien theory state, the mortgage creates a lien upon title to the property being secured, but does not transfer an ownership interest. In lien theory states, court intervention is required in order to enforce the mortgage via a foreclosure action. A deed of trust is commonly used in a non-judicial state. Texas, Georgia, and California are examples of non-judicial states. With a deed of trust, an ownership interest in the property is transferred to a trustee whose interest vests if the loan becomes in default. The non-judicial process generally allows the trustee to sell the property upon default in an auction without court intervention. So what is foreclosure? Foreclosure is the legal action to enforce a mortgage that results in the sale of the real property that secures the loan. Before a lender can start a foreclosure action, certain prerequisites must occur. First, the loan must be in default, either for the failure to make payments or for the occurrence of another basis of default, such as the sale of the property without the lender's permission. The Consumer Financial Protection Bureau, or the CFPB, regulates most mortgage lenders and requires that a loan with a payment default must be in default for at least 120 days before the loan can be referred for foreclosure. During this 120-day period, the lender is required to review the loan for loss mitigation remedies and try and help the borrower to cure the default. Now let's talk about the specifics of the judicial foreclosure process. The judicial foreclosure process generally starts with the filing of a complaint. The complaint is the legal document that is filed with the court and served upon the borrowers, title holders, and any lien holders. The complaint contains allegations of default and states the amount due. In addition to the complaint, The foreclosing attorney will file a lis pendens. The lis pendens is a document that is recorded in the public records where the real property is located to provide notice of the foreclosure action, so that anyone that acquires an interest in the real property is made aware of the foreclosure action, and anyone taking a new interest in the property will take their interest subject to the foreclosure action if their interest was acquired after the filing of the lis pendens. All interests in the public records prior to the filing of the lis pendens must be named as a defendant in the foreclosure action. The next stage of the judicial foreclosure process is service of process. The purpose of service is to provide a copy of the complaint to all defendants named in the foreclosure action. There are a few different types of service. First is personal service, which is hand delivery of the complaint and summons to a defendant. Personal service is the preferred method of service. The next type of personal service is substitute service, which involves hand delivery of the complaint and summons to a person that qualifies to receive substitute service for the named defendant. These persons are generally the defendant's spouse, a person residing with the defendant who is 15 years of age or older, or a registered agent in the case of a corporate defendant. The summons is a document that is served with the complaint that provides the defendant with directions as to when a response to the complaint is due and how to file the response. Another form of service of process is via publication. If a defendant cannot be located for personal service, a notice of action can be published in the county where the property is located. The notice of action describes the foreclosure action and provides information as to how the defendant who cannot be located can get a copy of the complaint and file a response. A copy of the complaint is also mailed to the last known address of the defendant who's being published on. After a defendant is served, they will have a set period of time to file an answer to the complaint. In their answer, the defendant must assert any defenses they may have to the foreclosure action, or their defenses may be waived. The next stage of the judicial foreclosure process after the answer period is to obtain a judgment from the court. A judgment is usually obtained via a summary judgment process or at a trial. The summary judgment process is preferred because it is normally faster than a trial. The plaintiff can motion the court for a summary judgment when there are no defenses raised that have not been overcome and the plaintiff believes they are entitled to a judgment as a matter of law. If the court grants the summary judgment, a sale date will be set. If the summary judgment is denied, the court will usually set a trial date. In a trial, evidence and testimony is provided to the judge by both sides in a very formal proceeding. The judge will hear the evidence and will make a final decision as to the plaintiff's right to foreclose. The court will either enter a final judgment in favor of the plaintiff, or they will enter a judgment in favor of the defendant and not allow the foreclosure to proceed. If a judgment is entered in favor of the plaintiff, the court will set a sale date. The next stage in the judicial process is the sale date. The judicial sale is a straight auction that is conducted by the clerk of court either in person or online. Notice of the sale must be published in the county where the property is located, and anyone can bid at the sale. The certificate of title is the document that is issued to the foreclosure sale purchaser, and it transfers title to the purchaser like a deed. After the sale, if the property is still occupied, the sale purchaser can request a writ of possession from the court. The writ of possession, which is basically an eviction, will require any occupants and their property to vacate the property within a set period of time. Now let's talk a little about the risk junctures for borrowers during the judicial foreclosure process. One area of risk for the borrower is with service of process. If the borrower cannot be located to receive a copy of the complaint, the borrower can be served by publication, as we have mentioned. The chance of a borrower not receiving timely notice of the foreclosure action increases when service is obtained via publication. If a defendant is served via publication, the court can only obtain in rem jurisdiction over the property, which means the plaintiff cannot obtain a deficiency judgment if the property sale does not result in enough to pay the loan off in full. Another area of risk is if the defendant does not respond to the complaint. The failure to respond to the complaint can result in the waiver of defenses. For this reason, a defendant in a foreclosure action should obtain attorney representation to make sure their interests are protected. Another area of potential risk for the borrower in a judicial foreclosure is during the sale process. If the borrower attempts to resolve the debt via loss mitigation, they must get their completed loss mitigation package to the lender prior to 37 days before the sale date. If they are able to do that, the lender is obligated to attempt to cancel the sale per CFPB rules. And this leads us to another risk when the sale is set, and that is being able to get the sale canceled if the borrower is able to work out a resolution with the lender. A court may not be required to cancel the sale post-judgment if the loan is not paid in full. To avoid this potential issue, the borrower will need to resolve the loan deficiency or the loan default as soon in the foreclosure process as possible. And this brings us to the end of part 1 of Lyons McCluskey's Foreclosure Basics course. If you'll go ahead and load up part 2, we can begin the discussion on continuing a little bit more on the judicial process and get into a little bit on the non-judicial foreclosure process, as well as some of the other foreclosure-related topics. Thank you.